Welcome, everyone, to the Ethics and Diversity in Family Law Mediation with our guest speakers, Jeffrey Fiorello and Candice Drisgula.
Okay.
Take it away, Jeff.
Thanks, Karen. And I welcome everyone. It's nice to see a lot of familiar faces and names on the screen. I'm going to try to keep this as interesting as possible. I know that this is probably end of the year, right? December 30th. Let's get our ethics and diversity credits in, and you'll get one of those ethics credits and one of those diversity credits today, those elusive credits. But we're going to try to keep it interesting and fun and upbeat as we go through some materials that are, I think, usually dense. But let me start by introducing myself for anyone on the screen who doesn't know me. I'm Jeffrey Fiorello. I'm a partner at Cohn, Lifland, Pearlman, Herrmann, and Knopf in Saddlebrook, New Jersey. My practice is exclusively family law mediation at this point. I have not been to court in probably about 7 years now, maybe closer to 8 at this stage. I'm a prior law clerk in Passaic County back in 1997 for Carol McCracken. I'm the past president of the Passaic County Bar. I am the immediate past chair of the family section of the New Jersey State Bar Association, where I currently continue to serve and serve alongside with Candice is on that board as well as a trustee. I'm a past trustee of the New Jersey State Bar Association, and I could probably go on and on, but no one cares about that. I'm here today to try to give you guys some information about how to integrate some information into your practice of mediation, both as a mediator and as a participant, to try to make it more meaningful, and hopefully we'll get there. I'm going to let Candice introduce herself, and then I'll talk a little bit more about ethics and diversity.
Thanks, Jeffrey, and thank you, Karen. Welcome, everybody, to our seminar today. I really appreciate everyone coming and attending during this quiet week in between holidays. I know it's the sort of the year-end rush to get these credits in, and I'm happy to see as many people as we have today and all these familiar faces. So for those who don't know me, I'm Candice Drisgula. I'm the principal of Drisgula Divorce and Family Law. My office is located in Wayne, New Jersey. Jeffrey's my hero. I wish I could say that all of my all of my practice at this point is devoted to mediation, but I still do a significant amount of matrimonial litigation. I do a lot of mediation. I also am a parent coordinator, and I am often appointed as guardian ad litem. I am currently the president-elect for the Passaic County Bar Association. I will be the incoming president for next year. So everyone mark your calendars, May 8th, if you want to attend the installation dinner, which is always a fabulous event. I serve with Jeffrey as a member of the Family Law Executive Committee for the State Bar. And I also am on the training panel for parent coordination for the New Jersey State Bar Association. We do have another training coming up in, I think, March. So for anyone who might be interested in parent coordination, you can certainly, if you want any more information, feel free to reach out to me. But mediation, alternative dispute resolution, much like Jeffrey, is something that's near and dear to my heart. So I am always happy to be on a panel like this with him.
All right, great, Candice. There is in January, if anyone is not a mediator and would like to become a court-approved mediator, the State Bar, New Jersey State Bar, is offering the course. I believe it's the last couple of weeks in January and first couple of weeks of February. I'm going to be an instructor of that. And at the end of February, Candice and I will be doing a seminar. You have to do, if you are on the roster, you need to do a 4-hour refresh every year. You're supposed to do a 4-hour refresh advanced mediation workshop. And Candice and I will be participating in that through the New Jersey State Bar Association. Those dates, I'm sure, will TBD and TBA. Anyway, um, Candice and I tend to work a lot in tandem in cases, not only as litigator, but through mediation, you can really become, I think, more creative. I've started to take this more collaborative approach to mediation, and it's not capital C collaborative law, but a small c be collaborative within the mediation process itself. And what I've done is I sort of borrowed. These elements of collaborative law and from other areas of alternate dispute resolution. And I try to integrate them when appropriate into mediation. And, oftentimes work in tandem with a mental health professional, work in tandem with a forensic accountant, work in tandem with a parent coordinator, oftentimes Candice. and to try to see how these things work and interplay together. But when you do that, I think it's extra important to be on top of ethics and what the diversity is within mediation. Because if you're going to start regular mediation, it's easier to keep everything clear. When you start to bring these other things in, you really have to make sure you've got your ethics and your diversity solid so that you could navigate that process and really serve families, especially in high conflict custody divorce cases. But I want to start by talking about diversity, DEI, and I've taught a lot of these courses. I'm a past chair of the LGBTQ rights section of the New Jersey State Bar Association. I've gone throughout the state lecturing on DEI. And the first thing I want to say is I don't get it right all the time. And a lot of people don't get it right all the time. I've actually written the definition card that the State Bar Association passes out that I think is going to be sent to you guys after if it hasn't been sent already. As part of the materials, I believe Karen is going to send that out at the conclusion of today. And I've written the definitions. So I'm going to tell you, I say things wrong because we're human and because the terms, I'll be honest, are evolving. Some of the terms on this sheet that was created back, I think, back when I was chair, which is about 5 years ago now, are considered antiquated, and the language has even changed on some of it. But it's still a good reference guide on most things. Don't be afraid to get it wrong. If you get it wrong, if you say something wrong, if you use the wrong pronoun, someone corrects you, say, I'm sorry, correct yourself, and move on from it. Don't make a big deal of it. Just move on from it. The first rule I think I put out there with respect to diversity is ask. If you don't know how to address something, if you don't know someone's customs or someone's holidays, because you're dealing with a custody parenting time schedule where there are rituals and traditions that are not familiar to you, ask questions. Same thing with pronouns. What are your pronouns? If you're interested. The way around that is mention people's first names. But that brings me back to immediately to diversity. Someone's first name, something as simple as that. Oftentimes I'm mediating for people who have names that I can't pronounce. And I know my last name is mangled throughout my entire life by teachers and I've heard it by judges. Judges made mistakes as they were saying it, and it was okay. I corrected them. But something as simple as a first name. In mediation the other day, I was mediating, and I immediately asked the party. I said, how do I pronounce your name? Oh, it doesn't matter. You can just call me G, or whatever it was. And I said, no, but what is your first? Tell me what it is. I want to know what your first name is. I'm going to write it down. I can write it down phonetically. I can say it, and they told me, and I used their name through the whole process. At the end of it, they thanked me. They said, "Thank you." My whole life, I've always felt embarrassed and like I couldn't, and my name has been mangled, and that's why I just tell everyone to call me G. I said, I'll call you whatever you want to be called, but I can write down on my sheet of paper that I sit and mediate with phonetically what someone's first name is, and that little piece alone could build credibility immediately and a connection immediately with a party in a way that it's as a mediator, you walk in a room and it's your job to connect with people in an instant, essentially, and then convince them to do things they don't want to do. So that only happens when you're able to make that type of a connection. So that little simple thing of just pronouncing someone's name right can immediately build credibility with you and that kind of a connection, some type of a connection with a party in a way that, it's a shorthand. It's a way to immediately move yourself from point A to maybe point C or D, skipping over a couple of levels of let's get to know each other first. Just showing that level of respect. I don't think people do things intentionally to be wrong and to get it wrong. I think most people want to get it right. And I tell a lot of stories, a lot of war stories in this because I think there are examples. They're not just this is what happened and that's what happened. A lot of the war stories I integrate into these presentations are because they are great examples of what you should do and what you shouldn't do. I was mediating, I want to say 10 years ago, a case where there was a transgender child involved, and the attorney in the case was an older gentleman and very nice, and he was representing the gender affirming parent, the parent that was acknowledging the fact that the child was transgender, and he was trying to say it right. He was trying to get it right. But I think he kept saying transsexual and using tranny and stuff like, and it was just the things that today I would cringe at. Back then it was wrong as well. And I stopped him, and I didn't do it in front of his client. I didn't do it in front of the other attorney. I said, you want to come into my office? It was something we were doing in person. You could just as easily do it in Zoom. I said, look, the term isn't tranny, and they're not transsexual. They're transgender, and they are a trans child or a trans person. They're a transgender, and they are a trans man or a trans woman would be the terms that we use, or a trans boy or a trans girl. And he thanked me, and he corrected himself, and he got it right, right? So he wasn't trying to do it wrong. He was trying to be doing it right. He just didn't know. And he appreciated that. And that's what we hope for, right? We want to educate people and make sure that people are doing it right. Um, I have just as many, unfortunately, bad examples as I have good examples in cases. I have another case where I was dealing with a case where one of the parties had transitioned. The prior husband in the case was now living as a trans woman, and their former spouse, was not dealing with it terribly well. Um, and they had taken certain positions in a case where the facts just didn't substantiate their position. And as that started coming out in the case, and the attorney for this party started to get really frustrated by what was going on, as they could see that their client was getting frustrated, they resorted to the same behavior as their client. They intentionally started misgendering the other party. Instead of using feminine pronouns, using her or she, they started saying things like, in emphasizing it. Well, he did this, and well, I wish he would go and do that, and stopped using their chosen name and was using the name that they were given at birth, and use the gender assigned at birth. At that point, at the end of the mediation, I asked that attorney not to utilize me any longer. I said, but what they had done was inappropriate. I thought was borderline unethical, because it is an ethics violation to do such things to people. I mean, if we can't use derogatory commentary to against parties. If someone used an N-word to describe a client, I think there would be an ethics grievance brought up against them. I think there should be similarly in these instances. I did not, because I make it a practice of mine not to bring ethics grievances against colleagues. But I asked that attorney, please don't send me any more cases. I think the attorney was quite embarrassed by the end of it. The attorney has since subsequently used me and has stopped that behavior. I think they were quite embarrassed by what had happened that day. But we don't always see a lot of the lessons that we learn are not born out of the best stories, or born out of the worst stories and out of the worst of people. So that's my overview on DEI. I wanted to punt to Candice and ask for her perspective on this, and if she notices anything different when she's dealing with other types of ADR, when she's dealing maybe with parent coordination, and what her perspective on diversity is through that lens.
Thanks, Jeffrey. And really, I think in all of the ADR arenas that I utilize, or I'm involved with, I see a lot of crossover in terms of addressing the issue of cultural competency. And I feel very privileged, because when I do the parent coordination training for the state bar, I am the one who gets to deliver the portion on cultural competency. And I think it's an incredibly important part of what we do, because our objective, certainly, and you're trying to ultimately, as mediators, get people to a resolution. But I find that the easiest way to get people to a resolution is to connect with them, and to make them feel like they're being heard, and to make them feel like you understand. Because oftentimes we all see it, I think, when people come into the mediation space and they've been in litigation for so long, and they're all entrenched, and they're in their, I always can, equate it to a boxing ring, and everybody is retreated to their corners. And you oftentimes hear from your clients, they just want to be heard, and they feel like if they could get to a judge, they're going to be heard. So in mediation, I like to give that opportunity for people to feel like they're getting heard. And one of the easiest ways or best ways to do it is to find those those places of connection with them. So when we talk about cultural competency, I always like to emphasize that, there are different I say there are 5 different components to cultural competency that we should all be aware of. The first is awareness and sensitivity. You have to be aware of not only the other the people that are coming into your space to seek mediation and assistance from you, but you have to be aware of your own cultural background and how you are maybe utilizing what you have experienced in life, in your mediation process. And you have to see where the commonalities are, but you also have to see where the differences are. I think one of my biggest challenges always is to make sure that I'm not interjecting either in mediation, parent coordination, whatever I'm doing in an alternative dispute resolution. I'm not taking my own, I don't want to say baggage, but my own personal history and sort of inflicting it on other people. So you have to have that very, very conscious awareness, and sensitivity to the people that are coming to you may see things very differently than you do. The second component being knowledge. You have to acquire information about diverse cultures, about LGBTQ issues, definitions. I have Jeffrey's sheet always posted whenever I'm working with individuals, because I think it is a constant reminder to me of the awareness and the knowledge that I have to acquire. I also have developed sort of like a body of resources, my go-to people, my phone of friends that I know if I'm dealing in cultures that I may not have a lot of personal familiarity with, I'm getting on the phone and I'm asking about cultural norms. I'm asking about traditions. I'm asking about different things that I need to be aware of, so that when people come to me and they want to address and resolve parenting time issues, that I can at least come to the table with some basic knowledge. Then there's another component is skills. You have to develop that skills of effectively and respectfully interacting with people. One of the things that I learned early on is that you have to meet people where they're at. So if I know that I have, one of the biggest examples that I oftentimes give is, if I know that I'm doing a mediation and it's less, it happens less now because I don't do as many in-person mediations as I used to do. But when in-person mediation, if I'm doing an in-person mediation and I have folks who are fasting, I'm not offering them lunch. Whereas in normal mediation, oftentimes I will offer people lunch. And it's just developing that sort of skills and awareness to be able to meet people where they're at. Attitudes is another component where you're just cultivating that open-mindedness, respect, empathy, non-judgment. You have to practice humility. As Jeffrey pointed out, one of my biggest aspects of cultural competency is always ask. If you don't know, ask the question. If you get something wrong, apologize. People will have a lot more appreciation when you practice humility than if you try to assume that or pretend like you assume that you know everything. And then adaptability is the last component. There has to be some flexibility to adjust to different communication styles, to be inclusive, to be responsive to cultural needs. I also give another example when I'm doing my training portion in the parent coordination classes of, I'm from an Asian culture, so I know what Asian culture norms are like. Other people may not be as sensitive to it. And I had a mediation years ago, and this goes to the issue of power imbalance. Also, I had a mediation where it was the woman was an Asian woman, and during the entire mediation, she was very quiet, barely said a word. And then we would go into caucus, and she had a whole lot to say. But during our general sessions together, she would not say a word. And I was afraid that she was feeling like there was a power imbalance, but I learned that it was really more of a cultural thing for her, where speaking up, being vocal is seen as a sign of disrespect. And while she had a lot of opinions and a whole lot of things to say, she had just learned through cultural upbringing that there were appropriate times to voice your opinion and other times were not. But had I not been sensitive to that, I would have just assumed that there was this outrageous power dynamic, and I may have approached the mediation in a different way. So I think we just have to be willing to be open-minded, willing to be sensitive to all of the different the different cultures and the different people that we have coming to our table, because ultimately that's what's going to help us get these people to where they need to be, which is to a settlement.
Right. I like to divide cultural competency, in my view, into there's two parts to mediating, probably more than that. But if I look at it as two general parts, there's not just substance of what you're doing in your case, where in divorce cases, substance of cultural competency becomes very important because of what you're doing with building parenting plans and with what your division of certain assets. And I'll get into that a little bit more later. But I want to talk a little bit more about what I think Candice touched upon is the form, right? It's not just substance, it's mediation form, how you structure your mediation, how you choose to run your mediation. So much as extending a hand to shake someone's hand can be very offensive in certain cultures to women. Women are not allowed to shake hands in certain cultures. So don't extend your hand, right? Or try or don't be offended when they don't, if you do it by accidentally, don't be offended that they don't put their hand back out to shake your hand, because it may be something that their culture does not allow or permit. um and again, this is something I've learned. This isn't something that I was born with, or that I think I always did in mediation. But the same thing with lunch. I if I'm I don't often do an all day mediation, but instead of offering lunch, what I do is I give people a break. Let's take a break. We're going to take a half an hour break. If anyone does want to eat, there's a cafeteria. If anyone wants to go and take a breath of air, you can go for a walk. I don't say, let's all eat now, is not what I'm going to say. In my case, and I don't just do it across. I think I sort of do it across the board now, as opposed to just saying, we're going to take a break. Whatever we want to do on this break. If this is the time, if you want to eat now, you could eat now. If you don't, and you want to do something else, this is a good time to do. If you want to check email or do something, so I try to normalize it. So if half the people are eating and the other half aren't, I sort of set it up that it's okay to do whatever you want to do. This is your time off. If you want to spend it making phone calls, make phone calls. If you need to check email, check email. If you want to eat, eat. Right? So it's not just oh, we're not going to eat today because I'm not going to offer it today. So I try to normalize what it is that I'm doing through my own process. I don't know if that's right or wrong, but it's how I've become adapted handling situations where I've gotten myself into in the past, where which may have otherwise been awkward. So I think that the form, rather, of how you run your mediation can be very important, from a cultural competency and from a diversity, through that diversity lens. Um, we all do have our own implicit biases, no matter how many tests I take or courses I take or teach. I still have my own implicit biases that we all bring to the table. But trying to be aware of them, and have them in the back of your mind, so you don't wade into a minefield, so to speak. The last thing you want to do is step on someone's toes, or make someone feel awkward or off put before you've even gotten to what the substance of how you're going to resolve their matter. Um, by way of example, I ended up mediating a case that had been through an ESP, with an Asian Indian family, a South Indian family, and they had gone through. They had such a bad taste for ADR. They didn't want to come. They didn't want to mediate. And I asked their attorneys. I said, "What's the problem?" And they said, "Well, when we were at our ESP, um, the gold came up. The issue of the family gold, and the gold that's given customarily at a wedding, had come up." And one of the attorneys, I think, I use humor a lot in mediation. I feel like it breaks down walls, but I always make myself the butt of the joke. I use humor and insult myself to see if people chuckle. Are they gonna, something self-effacing? Am I gonna connect with them, loosen it up, make it feel a little more comfortable, so that they can feel like they're gonna talk to me? But I think the attorney was trying to do that. But what the attorney said was, "Oh, we're talking about the gold. What are we going to talk about next? Who gets the third cow?" Um, and the parties were so offended, and I understand why. I think the attorney was trying to be humorous, and obviously it did not land. And again, through teaching these courses and writing these articles, I learned from Judge Bhattacharya why the gold is so important. Shukti Bhattacharya, who sits on the bench in Mercer County, and I and a couple of other attorneys, actually now judges, Judge Vallejo, Raquel Vallejo, and a few other people, we co-authored an article on looking at diversity through various different lenses. And the significance of gold is that in the Indian culture, gold is given, it's almost like a dowry, so that if a party if the spouse dies, the gold is supposed to be there to support them. So the gold isn't just, oh, who's getting the gold? I mean, the gold has this cultural implication that is much deeper than just the fact that it's a material item like that would be a piece of jewelry. So just having that understanding, and I have that understanding, brings. I don't ever make light of the gold, right? I mean, it gets frustrating. You feel like you settled the whole case, all of a sudden the gold comes up, inevitably, and in these cases, and it's like, oh, now we have to deal with that. I don't roll my eyes any longer. I don't get exasperated. I know it's important to them, and I know I have to address it, and I know why it's important to them, and just having that piece of knowledge and walking into the room with that piece of knowledge puts people at ease, builds the credibility with you, and then I'll make a more appropriate joke about what I don't know, as opposed to making a joke at someone's expense. And that's sort of how I look to that. But again, as Candice was saying, it's a lot about education as well. I was dealing in a case where there was a Maher agreement, and the attorney kept referring to it as as a dowry. And they're saying, well, this is their dowry, this is their dowry. And I said, well, is it a dowry or is it a maher? And they're saying, no, I don't know what a maher is. And the client finally said, that's what it is. The mediator's saying the right thing. That's what it is. And the fact that I knew what it was, I mean, I immediately built this credibility with the client in a way that and the attorney like had then came back to a second session. I referred them to, they asked me, I talked to them one-on-one, referred them to a couple of cases and some articles that they might want to read about the significance of Maher and how Maher is still enforceable outside of the divorce case, beyond just what equitable distribution is. Some people think it's just that's all you get. It's not a prenup. Maher agreement is not a prenuptial agreement or a dowry. It's something that is unique unto itself, and there are reported cases that address it. And knowing that piece of knowledge and having that little piece of knowledge enabled me to be able to resolve this case. Neither attorney in that case knew what a maher was when we started it, and both of them left knowing what a maher agreement was by the end of it and how you're supposed to address it in mediation. But it's these tools that you pick up along the way. We all bring to the table what we bring to the table, and how that's kind of governs how I run my process. And let me be clear. What I do is not what everyone should do. Mediation and ADR is never one size fits all. I'm the first person to say I am not everybody's mediator. I'm a lot of people's mediator, but I am not the right mediator in every case. And there are cases and instances when I have referred cases to other parties. I've said, and at the end of the initial session, look, I don't think. I'm your mediator here. I'm going to give you a list of two names or something of other mediators that might be appropriate. There was one case where there was where I was dealing with someone whose primary language was Spanish, and I speak like this much Spanish. But the other party, English was clearly their second language, and they were having a difficult time with it. And I kept saying, I want to bring in a translator. And then, well, my wife will translate for me, the husband kept saying. Well, your interests are adverse. So I don't know that that's overly appropriate. And they kept insisting and insisting. And I ultimately sent them to a Spanish-speaking mediator who was able to resolve their matter, probably much more quickly and expeditiously than I was able to do it because of the skill set that they possess that I didn't have. There are cases that I'm not right for because of the skills that I just don't possess. So I've tried over the years to pick up a lot of information on a lot of different cultures so that I can come to the table with a tool belt, so to speak, of a lot of information that I've armed myself with, that I can build credibility with parties and enable them to find the agreement. But I don't know everything, and I'm the first to admit that I don't know everything. And as Candice said, phone a friends are very important. I definitely have my list of phone a friends of people that I'm going to call in certain instances to find out about certain issues. And sometimes you could do that in advance if you have a good mediation submission from the parties or from the attorneys for the parties. And that's sort of, I guess, a practice tip that I think is important to take away from this discussion is that if you do have one of these issues. If you have a particular issue that you think the mediator or that is not common knowledge to most people, put it in your mediation submission, or if you feel that you can't put it in the mediation submission because it's going to offend your client, call me. Or at the start of the mediation, say, hey, Jeff, can I talk to you one-on-one? Sure, no problem. I'll put everyone in a breakout room, or you can come into, if we're in person, come and sit in my office. I'll have a one-on-one conversation with an attorney to explain a certain nuance of a case that either is something that is not common knowledge to most people that they think I need to possess in order to find a way to connect with their client, or substantively, I need that piece of information to help them facilitate that settlement. And it's important to have that type of information. And if you, like I said, if it's going to blow up your case because you're putting it in a submission that's going to go to both sides, don't do that. Send me a confidential submission if you are okay with your client seeing it. If you're not okay with your client seeing it, call me, text me. Yeah, I know most of the attorneys I work with, most at this point. Um, I like to think of myself as approachable. Let me know, tell me what the issue is. Give me the tools that I need to help your client settle their case. So as a practice tip, I think if you know that piece of information, don't hide it or conceal it from the mediator. Don't be embarrassed of it. Put it out front in some manner that you feel is appropriate, that isn't going to offend the other side or offend your client. Candice,
Yeah, I would agree with that, Jeffrey, because my practice tip also would have been, um, when I do mediation, I do the same thing. I generally start every mediation I have with a conference with the attorneys only, and I explain to the parties once they are in the room, whether it's in person or on Zoom, that look, we had a little conversation with the attorneys, not because I'm trying to leave them out of the equation. Obviously, it's their case, it's their life, but because the attorneys, we all speak the same language. So, and I always emphasize to them that my purpose of doing it is to figure out the best path to be able to help them to get to the end goal of resolution. So I like to always have that initial meeting with the attorneys because I do like to gather that useful information. What do I need to know about your client? What does your client need to hear? Oftentimes it depends on the attorneys that I have that are representing the clients, whether they feel comfortable having that communication with me, with the other attorney together. Um, if not, I always offer to have individual conversations with each attorney so that they can be open and candid about what their client really needs to hear in the context of the mediation and in order to get it moving forward. But I also I know sometimes I get very voluminous, as I'm sure Jeffrey does, very voluminous mediation submissions. Sometimes I get a one-page letter that doesn't give me a whole lot. I like somewhere in between, but I do like a lot of information in advance because it does, to Jeffrey's point, and to what we've emphasized, it does allow me to do a little bit because I prep for all of my mediations. I make all of my notes. And to the extent that I need to use a phone a friend to get a little bit more information or to explore an area more, it gives me that opportunity to do that. And on rare occasions, and I have done it as well, if I say, gosh, the issues in this case are really, I'm not equipped to deal with this effectively as I would like these people to have. I have called the attorneys and said, I appreciate you choosing me as your mediator. I would love to help you, but I think these folks, based on what I've received, would be better served by maybe going to see this person or that person. The self-awareness part of it, I think for me is always a big component. I'm big in sort of dialing into what I don't know in addition to what I do know, because I really my ultimate objective always is to help the litigants. And if they feel like you are invested in helping them, I think they are more responsive.
totally. And beyond just form, I think a lot of what we do as family mediators, as divorce mediators, substance comes into play with respect to how we're even as simply as how we're gonna craft a parenting time schedule. Food, right? As are we dealing with the kosher family? Are there food limitations with parties? And just having that knowledge or that piece of or that not even that knowledge. I mean, I'm gonna be honest, I don't know everything about keeping a kosher kitchen, but I know enough about people who keep kosher to be able to have a conversation and craft language and craft information into a parenting plan that's going to address that. And that's because I've done some homework over the years to learn that, and I've acquired some of that information. But Google is a wonderful thing. Outside of a phone a friend, I mean, Google is a wonderful resource. A simple Google search can oftentimes produce information for you that you otherwise don't know. I was dealing with once with a Jewish family that had a very, in fact, Candice, this is with with Amanda from your office, before she was at your office.
Before she,
And it was a case where there were the woman in the case was a rabbi. The mother in the case was a rabbi, and there was every holiday that could possibly appear on a Jewish calendar. Holidays that I had never heard of, that no the attorneys in the case had never heard of before. And I made I made a phone call. I made a phone call to a friend of mine, a lawyer colleague of mine, who I know is his wife works teaches Hebrew school and works at a synagogue. And I made a phone call to her and I said, Tammy, talk to me. Tell me what I need to know about this. Because I'm going into a mediation tomorrow and I want to have some knowledge about this. I'm not going to sit and absorb everything, but having those pieces of information are important. I've actually written an article. I think it's part of the materials called Fitting a Square Peg into a Round Hole. And as someone in the LGBTQ community, right now we have marriage equality for, I guess, 10 years now, right, with Obergefell. But a lot of gay relationships are in existence for longer than 10 years. And the law, in 20 years from now, this will not be an issue any longer because parties will have always had the right to marry at that stage. But now we have couples who have been together when they did not have the right to marry. And there are differences between civil unions and marriages, even though the law says it was supposed to be the same. It was never exactly the same. Separate but equal, as we've learned through history, does not apply. It doesn't necessarily work. So separate but equal with civil unions did not work, and a lot of with domestic partnerships, it really was quite different with what a domestic partnership is. So those things were not the same as marriage. So understanding that and understanding what you could possibly do to adapt that, right? There's no body of law on, well, this is what you do in that circumstance. So having that knowledge and having that information and the ability to adapt and think creatively about how to deal with those types of situations, right? So we know that you can only get alimony for the duration of the marriage, right? And usually we're talking like in counseling parties, you're going to get only for about half the duration, maybe a little better than half, depending on how long the relationship is. Well, in a gay relationship a couple that's been together for 30 years, but they've only been married for 10, because that's how long we've had marriage equality. We would never be counseling a client who's married 30 years, you're only going to get 5 years of alimony. So to look at it through that lens is not appropriate. So maybe that case, it is appropriate to be talking about the full length of the marriage, 10. Or is that an exceptional circumstance? Because, right, in exceptional circumstances, you can extend beyond that duration. Or is there some other way to provide for that? Like we're going to stretch it to 10 years, but we're going to give them a little more of the retirement assets. Because again, you can only divide the assets that were acquired during the marriage. And if you've acquired retirement assets for 30 years, but only 10 of them are acquired during the marriage, you're going to leave one party essentially destitute, with maybe 5 years worth, and another party is going to get 25 years worth from from all things that were acquired over the course of a 30-year relationship. So maybe that's a lopsided division of equity. Maybe that's not 50-50 of what the marital portion is. Maybe it's an 80-20 and that type of an instance. And having the ability to adapt and think like that, because we are essentially fitting this square peg into this round hole. The laws around was written through a heteronormative lens, right? Many of these laws were written before we had marriage equality, and they're still good laws, and they should be good laws, and they will be. Again, no problem with them. As I said, in 20 years from now, they will not be these. I will not be teaching. This course will not have to be taught in this manner because parties will have had that right to marriage equality unless something happens with that law. But being able to adapt now and know that and have that information and that creativity. I think a lot of people bring me those types of cases to mediate because they know I am going to come up with something like that. And parties are afraid to bring those cases to court because if you're going to a judge, trial judges are reluctant to make new law, right? I don't know that we're going to find what exceptional circumstances are. If it's that your relationship is longer than predates marriage equality, I don't know that a trial judge is going to say that that's an exceptional circumstance. I think that would be something that would be more ripe for the appellate division or even the Supreme Court. Trials are expensive, appeals are even more expensive. And in these cases, parties would rather not spend their money finding out, being the test case on whether or not same-sex relationship that predates marriage equality is an exceptional circumstance or not. So we don't have that, that law, that case that reports that. But bringing that piece to the table immediately enables me to connect with parties on a level that I don't know that every mediator does or can. And I think a lot of attorneys bring me those cases for that reason, because they know I'm going to be able to put the parties at ease very quickly with that and talk to them about the creativity and being fair, and through that lens that I bring to that piece that I have in my tool belt, right? As mediators, we all have tools and I say I play every card I got in my deck. If I have to, whatever card I have. And I don't have every card, but I have a lot of cards, and I play the ones that are appropriate when I need to play them. So, some people are offended by same-sex couples. My pride flag that's sitting over here out of screen is out of screen when that happens. In a mediation. If I'm dealing with parties who are, then I'm not so afraid to hide it. Although most people could Google me and find it out quite easily. But in any event, Candice, any thoughts on substance and diversity?
Yeah, I think I would encourage everyone to read Jeffrey's article, not just because he's my co-panelist and he's my friend and I have a great deal of respect for him, but I know I've read his article several times. The other article that I know he co-wrote with some of the other individuals that he mentioned, I also have read several times. And when I am prepping for training, I often reread them because it's a wealth of information. And given what we do, I think creativity is a key whenever I go into a mediation with whether it's just private individuals or individuals who are represented by attorneys. One of the things that I always emphasize to them is that the mediation space allows us that opportunity to come up with creative resolutions that potentially a court cannot give, or to Jeffrey's point, the landscape is too unknown right now to have any assurance as to what the court is going to give, but it is an opportunity to come up with those creative resolutions. It's also an opportunity to come up with resolutions that are very tailored to the family. When I first started doing mediations, I was a little bit blind to some of these concepts, as I think a lot of us probably have been, and we learn over time, and that's the importance of all of this. But when I used to work with private individuals, at the beginning of the mediation, before we even started our first substantive meeting, I would have my assistant send out a blank holiday schedule that had what I perceived to be all of the major legal holidays that you see on the court holiday schedule. And I would send it to them so that they could sort of mark it up and send it back to me in advance so that we could talk about parenting time and holiday parenting time. And very quickly, I realized that holiday schedule, and again, it's the one that oftentimes the court uses, is very sparse when it comes to diversity and recognition of all of the different observances that are out there, of the cultural differences that are out there. And I very quickly stopped circulating that holiday schedule because I recognized that it was assuming a one size fits all. When we are certainly in our geographical area, the population is far from one size fits all. And so now whenever I talk to individuals, particularly parenting time is a big place where cultural differences come into play. And we have the opportunity to be very, very specific. When I know that I'm dealing with, we can't do I had a Jewish family where a lot of the parenting time discussion took place about how we were going to handle Friday night. And dad wanted the kids on Friday night, and mom was a little less observant than dad was. And so we had a lot of navigating about Friday night. And we had to come up with a very creative parenting plan. It wasn't as easy as, okay, every other weekend, this is what we're going to do. We had to accommodate sundown. We had to accommodate the changes in the year when sundown occurs. We had to accommodate dad's wish to take the son to temple. We had a lot of navigating, very specific. We got very creative, but at the end of the day, we got it done. And I think one of the beauties of mediation, and one of the big parts that I emphasize when I'm working with people in mediation, is this is the space where we have the ability to do that. In a courtroom, they will never be able to do it. So if they want to come up with a resolution that's going to be most tailored to their family's needs, This is the place. And I think I have been successful, I'm sure Jeffrey has been successful in getting people to stay committed to the process because they recognize that this is the place where they're going to be able to get that sort of creativity and that tailoring where in a courtroom you just can't. But you have to be willing to dig in and recognize that we're not a one size fits all populace in order to be able to provide that service, I think, to people.
Yeah, I know there's a movement afoot in the state right now to try to create a more comprehensive holiday calendar. I know the Council
As
of
there should be.
working in tandem with the Family Law Executive Committee that Candice and I both sit on before. And actually it was mentioned to me last year when I was the chair, and I thought about it and I said, I think there are so many exceptions that this is going to become something that's going to be unruly. Now maybe I think it's going to be if you have a family that is this, you need this form. If you have a family that is that religion, you need this form. I think there'll be so many different addendums that it will just become unruly. I certainly think it's important to encourage judges and attorneys to think beyond um, the Judeo-Christian calendar, a holiday calendar, which is I think very much what the court holiday schedule is based on. That that most every jurisdiction sort of has its own, every vicinage has its own sort of holiday calendar that the judges sort of say, okay, well, this is my holiday calendar that I routinely give people, and that's fine. It's a good place to start. And I think they're going to try to include more holidays on that, sort of choose your own adventure when you need to. But I think that if you try to include everything, it's going to become really unruly. Now, I think it's important that people think beyond the scope of just that limit. But I don't know that this will ever become a fully all-encompassing, you don't need to look at anything else or find out anything else. This is just it. Because different families have different traditions, and sitting with parties and just talking to them about what's important for them. I was doing a holiday calendar the other day, and the party said, "Well, just tell us whatever you normally do." I said, "What you want to do? What I normally do? I mean, I could tell you, Christmas Eve is the most important holiday in my family, and no one cares about Christmas Day, so I'll just take Christmas Day off the calendar." Oh, no, no. I said, then don't tell me to do whatever I would do, because I would do something very different than what your family did. How did your family last year celebrate Christmas? Tell me that. And I start from there, and they start talking about it. And well, is that what you do every Christmas? Oh, no, every other year we're seeing that, this family or that. Okay, well, let's figure that out. And let's put you on that rotation, that odd years, even years, that rotation exists, for parties that you're honoring what they want to do, and honoring the family tradition so that the children can benefit from experiencing those family traditions.
I do the same thing, Jeffrey, whenever I start talking about holidays, when I talk about how I always ask them, I don't make any assumptions anymore. I always ask them, tell me which of the holidays are important to your family. I don't assume that people care about the Mondays off from school. I don't assume that people care about 4th of July. I don't assume anything. I tell them, you have to tell me which holidays are important to your family. And then I do the same thing. I work backwards and I say, okay, let's talk about if they are Judeo-Christian, tell me about Christmas. What did you typically do? Well, we always went to, mom's side on Christmas Eve and always dad's side on Christmas Day. And we incorporate, well, can we continue to do that going forward? Always remaining child-centered to make sure that they get the experience. And it's less about mom and dad, it's more about what's best for the children. But I always take the position of tell me what's important to you, and we'll work from that. We'll work within that framework. That's where we're going to focus.
Absolutely. I think that's probably a good place to stop with diversity to pivot, and we have to get our
Our
15
ethics.
ethics to get you guys your ethics credit. I will say if anyone has any questions, feel free to post it in the chat, and I'll do my best. Candice and I'll do our best to try to address whatever questions you might have, or if there are questions that you don't feel comfortable posting here, my contact me at my firm, send me an email, make a phone call. I'm happy to get on the phone and talk to anyone. I know Candice is as well, where she's certainly I was very generous with her time with me, and I try to do the same. We want to help people. There's only benefit in having more knowledge out there and having more people become educated on these things.
That is true. Jeffrey is on my phone a friend list, so and I'm happy to be on anyone else's.
So, but I want to pivot and I want to talk a little bit about ethics. Um, let me get out my outline so I could follow along. Okay. Okay, NJSA 2A 23C is where most of these definitions and information with regard to ethics appears with respect to mediation. The first part of the statute defines things, what a mediation communication is, what a mediation party is, a non-party participant, how to treat them, and what even a person means, what a proceeding means. But I want to talk more. Outside of that, I'd rather talk, I think, about privilege and confidentiality because I think that's something that comes up a lot in mediation, and I want to address some of that. And in a proceeding, there are certain privileges that apply. Number one, a mediation party may refuse to disclose and may prevent any other person from disclosing a mediation communication. Two, a mediator may refuse to disclose mediation communication and may prevent any other person from disclosing a mediation communication of the mediator. And three, a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication of the non-party participant. So I have those are the general pillars of what you could be disclosed and whatnot, but I want to talk a little bit more granularly about how these things work. Um, Candice, what do you tell parties in your mediation about privilege and confidentiality?
I think probably anyone in this room who does who mediates, and I know Jeffrey does this, I do this. I start every mediation with a joint session before I create breakout rooms. I have a joint session where I go over essentially, even if their attorneys have explained to them what mediation is and what mediation is not, I take the time to make sure and give them my explanation of what mediation is and what mediation is not, and I give them sort of the rules of the road. But one of the big components of that is explaining to them confidentiality. And I have this little ongoing joke that at this point is getting a little dated because the commercial's no longer on TV, but there used to be a commercial on TV about Las Vegas, what stays in Vegas, what happens in Vegas stays in Vegas. So I always say what happens in mediation stays in mediation. And I do it sort of tongue in cheek, but it's to emphasize to them that whatever we talk about in the mediation space is confidential. It's going to stay there. It can't go outside of the walls of the room. If they go to court, they cannot tell a judge. When we were in mediation with Candice, this is what he said, this is what she said, and now they're saying something different. And I break it down really that granularly of giving them examples of what they can and cannot do. And I explain to them why, which I think is an important piece of it. I explain to them that you really want to give everyone an incentive to be able to put their best positions forward without fear that it's going to be used against them in a courtroom. Because if people aren't coming into a mediation open-minded, willing to talk about compromise positions, willing to explore alternatives, then it just hampers us and it handcuffs us from being able to do our job. So I do spend a significant amount of time with the parties, with their attorneys present, explaining to them the issues of confidentiality and why.
Yeah, I do much the same. Um, I want to talk about let's see, there's exceptions to privilege within mediation. I want to talk a little bit about that. If you're in a mediation candidacy and the party produces financial documents, and that matter does not resolve in mediation, can the other party propound a notice to produce those documents later after the mediation?
Absolutely. I don't think that there's any prohibition against doing that. There is a part of the mediation statute, and if I if I had more time as we were sitting here, I'd pull it up. But there is a section that says that things are not considered privileged or confidential if they are can be obtained by means outside of the mediation. So our discovery rules have a whole set of different ways that we gather information, whether it's interrogatories, notice to produce, a very underutilized request for admissions. If we can get all of the information independently outside of the mediation space, I don't think there is anything that precludes somebody from doing that.
Right. Yeah, no, I completely agree with that. Parties obviously, if there's information that comes out, we can't use the substance of what came out in mediation, but if you can get it some other manner, you certainly have the right to do that. If you found out about something. So if you have a client who really wants something that does not they don't want to be disclosed, make sure that it's not that it doesn't come out. Um, for a prime example of that is an investigative report on a cohabitation, right? If you reference, I have a report on cohab, you may not want to reference that if you're going to use it in litigation, which is how do you navigate around that? I don't know, and it could be deemed work product, so I think there are ways around getting it, but I think you have to be cautious in certain instances. The line gets a little muddied in certain instances.
Let me ask you, Jeffrey, have you ever had a circumstance as a mediator where one of the parties tells you in caucus, look, by the way, my client obtained an investigative report because we believe there's cohabitation. We don't want you to tell the other side that we have it because we're not sure we're going to use it, but just so you know, it's been obtained. As a mediator, how do you handle that?
Yeah, that happened yesterday.
Timely.
But yes, it does happen in mediation. What I do is I talk to them about, is there any information that you know outside of what's in the investigative report that I can mention and talk about? So that's how I got around that. I was able to talk about things that were discoverable on Instagram, and things that were mentioned by the child, and things that were verifiable. The cohabitant went to doctor's appointments with the children, so. That's something that would be otherwise discoverable outside of the report. So I talked about things that could be found outside of the report that could have been either public knowledge that the person has put out on some type of a social media based platform, or that could have been heard from the children, or from a teacher or from a doctor, information that could have been attained elsewhere outside of the investigative report. Obviously, I can't say, and we had a camera that saw the car there however many nights a week, or however many nights a week for however many weeks. That kind of a thing I think would tip the hat. So obviously I didn't give that type of information. But I talked to the parties and I made a very specific list of the things that I was able to mention and talk about. So that I was able to go over and have a conversation about the exposure that there could potentially be on Cohab. The way that we ultimately resolved it was that we shortened the duration, we lessened the amount slightly, and we made it non-modifiable for Cohab. So we said, look, if the party is cohabiting, they're allowed to cohabit, it won't affect it because we're only going to pay a year of alimony as opposed to 3 years of alimony. Or whatever, however we under something along those lines is how we ultimately ended up resolving it, as a workaround. I think we had a question posed, Candice. Do you see that?
I do see that.
Okay.
But now I can't see the actual question.
Neither can I.
It's not pop up.
Oh,
Oh,
here we
wait,
go.
I have it. The question is, can a case be effectively mediated when there is a language barrier? In other words, where one or both of the parties speak a foreign language or no English?
I have done that, where the attorney speaks the language, or I've done it with an interpreter.
I have as
Um,
well.
So I've done it in certain instances along those lines. I think you just have to set up the rules of the with the interpretation the way that a court would, like let the interpreter finish speaking and telling me before we're speaking over each other, because the interpreter can only interpret for one party at a time. I also have an earphone, a device that translates when someone's speaking. It'll translate in my ear. It's not perfect. I've done it with attorneys who speak the language of their client. I just have to, sometimes caution the attorney, right? Like I'll ask a question, the attorney will ask their client, and they'll have a 5 minute conversation. The attorney will turn around and say yes. And I'll say, okay, hold on, because you just said a whole lot more than yes. So I need to understand some of the context of that in order to be able to, yes, maybe isn't the bad. Maybe if they say no, I need to understand why no, so they can come up with a well, then what can we do to make it a yes? And without that information of what happened in that conversation, it becomes difficult. So there are certain attorneys that will bring me those cases, and I'll say, look, if your client's comfortable with it and you're comfortable acting as a translator, I'm not going to stand in someone's way and say, look, I won't mediate. If someone tells me they want to use me and they're attorneys that I trust and that I've worked with before, I'll do it. So I have successfully done it in cases where I don't speak the language.
I have as well, and I had one case, and it's only been one time where I was dealing with private individuals. They were not represented by attorneys. They wanted to use me because one of the parties, a good friend of theirs, knew me and had faith in me. So they wanted to use me, but they were both Spanish speaking. I am not Spanish speaking. But they had a mutual person that they both agreed, that they both trusted, and they agreed would be part of the mediation just for that purpose. And it was someone in their family, and it was very helpful. And we were able to get it done. But it can be done. And you just have to arrange it in a way that everybody feels comfortable and you feel that the process is effective.
Yeah, I also feel like it's, I mean, my boyfriend, I'm letting you can, my boyfriend speaks fluent Spanish. So I do not. But I certainly have picked up some and I understand more than most people, than, I don't know, certainly more than I did before he and I dated. But, so the other day I was mediating and someone was saying something in Spanish. I don't think they wanted me to understand it because they spoke English and they were saying something to their attorney in Spanish and I answered them in Spanish. And the look on their face was like, wait, what? So, never presume that someone doesn't understand you. Make sure your clients understand that. I never try to play it as a gotcha type of a moment, but I can't unhear certain things. If I understand them, I understand them. Certainly, if parties want to have a confidential communication outside of the mediator, I have no problem doing that. Tell me, Jeff, before you go to the other side, I need 5 minutes with my client. Great. Take 5 minutes, take 10 minutes, take whatever you need to do before you bring me into the conversation if it's going to make your client feel more comfortable and relaying what they want me to relay. So I think that that's, something, another takeaway. Candice, can a party depose individuals whose names were discovered during a mediation session? Right? If it's confidential and names come out, can you serve a notice to take someone's deposition and depose that person?
I think you can if you can obtain those individuals' names by way of regular discovery requests. If you tailor your discovery request to get identification of people and those people are disclosed, absolutely. I don't think there's any reason why you could not depose those individuals.
Right. Right. Um, This one's, I think, a little bit more difficult, right? Some of these are black and white, some of them are much more gray. If a party admits in mediation improper conduct in front of children, drug use, alcohol abuse, or physical abuse, does a mediator have any obligation to report? And can the parties use these statements to a mental health professional in a litigation?
I know if I were, and I can speak for myself, I think we have a reporting responsibility when it comes to issues related to safety and well-being of children. So if I hear that somebody admits that they have engaged in any sort of abusive conduct, whether it's substance abuse, physical abuse, emotional abuse of a child, or sexual abuse of a child, I think I have a responsibility to report that conduct. Now, I think that the mediation statute carves out, even as an exception, if there are things that would be considered unlawful or fall into, categories of crimes that there's an exception to some of that confidentiality and that privilege.
Yes. Yeah, I agree with that. I do agree with that. I think, although I think it's rare that someone's going to admit something like that in a mediation, quite
I
frankly.
would be surprised. It's never happened with me, but I would be surprised if somebody were so bold.
Right. Right.
Usually it's more the other side making the accusations. It's never the person who's,
Correct. Correct. In which
yeah,
case it's hearsay or I heard or I think or I know.
yeah.
And there's certainly two sides to every story. Um, can a mediator continue in a mediation if it's disclosed in a caucus that there are assets which the other spouse is unaware?
I also give this speech in my preliminary conversation with everybody. When I talk about the fact that it's confidential outside of our mediation space, I say in general, there are different rules with confidentiality within our mediation space. And I give the examples of like when we caucus, obviously there's information that sometimes people will say, their attorneys will say, look, we're not prepared for you to present that to the other side. We don't want you to tell the other side yet. Position wise, that's fine. But if somebody comes to me and says, look, I've been funneling money into an account in my mother's name, and I've been doing it for years, and I don't want my spouse to know about it. So, yeah, I'm willing to accept this deal because I know that I'm going to be fine. I make it very clear that I have certain obligations that I can't not disclose that. We either have to disclose it or I have to politely dismiss myself as the mediator from the case. Because I don't think that a mediation can be successful if there is not full transparency. And I go through with them. It's intended to be a transparent process. It's intended to be an open and fair process. And if we don't reach that level of transparency, then I can't be participating in that.
Certainly with assets, right? There has to be a full disclosure of assets. All these agreements are predicated upon full disclosure of
Full
assets.
disclosure. And I will explain to them if that circumstance, and it's only happened one time, where we ended up putting everything out on the table, but it was more sort of, I wasn't told that there was hidden or undisclosed assets. It was raised as a question to me of, well, what if? And I explained to them, look, the premise of any agreement that ultimately is reached and is inked and signed, and when you testify as part of a divorce, you have to testify that it encompasses everything. So if it doesn't encompass everything, you're only opening yourself up to further litigation going forward. You're opening up yourself up to allegations of fraudulent conduct. And why would we do that? If we're coming into mediation and we're doing this in good faith, why would we start on that foot?
Absolutely. Let me make the question a little bit harder.
Oh
Someone
boy.
discloses you're dealing with right. Why just start you the easy one? So let's make it a little bit harder. Someone tells you, look, I want to negotiate an alimony buyout because I have a boyfriend and we're going to get married. When this is over, I'm going to get married to my new boyfriend or girlfriend, and therefore I want to negotiate an alimony buyout. And you start negotiating a buyout. Do you have an obligation to disclose that the other party has a boyfriend or girlfriend that they're planning to marry?
That is a harder one. I am not a fan of keeping that sort of information completely undisclosed. Like if we're talking about an alimony buyout, I make sure and I discuss in both rooms, here are the pluses and minuses of an alimony buyout. Here are sometimes the circumstances that, people will want an alimony buyout. Here are the risks to the payor of an alimony buyout. I don't know that I would necessarily say, hey, by the way, here's the reason why your spouse wants one, but I certainly would make it very clear to both sides, all of the risks and potential downsides of an alimony buyout, including if this person got married tomorrow, FYI, you've already prepaid and you lose. But to the person who's looking to not disclose it, I would again have that same conversation of, you're potentially opening yourself by not putting this information on the table and being transparent about it. You're only opening yourself up to future litigation because if it's not disclosed and then 2 days after you're divorced, you get remarried or you have it, then you're only putting yourself at risk. And again, why would we do that if we're trying to get to a resolution?
I agree with like 99% of what you said. There's one extra caveat I throw in there. There is no guarantee. A fact of an account, an undisclosed asset, an asset exists. That marriage does not guaranteed exist. I've seen in many cases someone who has a boyfriend and a very serious boyfriend, and they don't, they're going to waive alimony because they're going to get married. And the second they get divorced, that boyfriend is like, oh, well, I don't want to get married. I have no intention to marry you, right? People say what they say in the throes of a relationship. But then when it becomes a reality that they actually can, there's no guarantee that that marriage will happen. There's no guarantee that it's not definitive the way that an account would be. That relationship could end, that relationship could break up. The new boyfriend or girlfriend could decide they don't want to get married. They change their mind, whatever that is. But I think more importantly is exactly what you said though, Candice. Really explore with the other side. I don't ever do an alimony buyout without laying out what the exposure is, right? Like talking really, really seriously about what the consequences could potentially be because there's no give back. Once you pay it, you don't get it back. So if you've paid it, then and the party does remarry, 2 weeks later, you're not getting the money back. So I lay that out to parties. Look, you're going to be okay with that. I use live with it, right? I always talk about anyone who's mediated with me has heard me say live with it. I don't make people happy. I'm not going to find anything that's going to that anyone's going to like. I find something that everyone could live with. So I bring it back to that. Could you live with it? If you pay this party $100,000 and they get married in a week, could you live with that? Because if you can, fine, do it. If you can't, then think twice before you say you're going to do it. So that's what I do. And then I'll talk to the other party then when if I get a really low ball buyout number and I bring it into the and the party say, well, I want more money. And I say, really? Because this is a case where you're giving me information where if I'm going to value alimony, I'm going to give it a very significant discount. So if you ask me to calculate an alimony buyout, in a normal case, I'm going to use a discount rate of a 4% present value and a 1 to 2% risk discount. I usually put in 1% for every 5-year duration, right? If it's going to be a 15-year case, maybe I'll use 3 extra percentage points. So I'll use like 7 in a 15-year alimony buyout. Whereas if someone tells me I have a boyfriend and I'm going to get married in the next year, well, maybe I'm going to use like a 10 or 15% discount rate when I'm figuring out what that discount rate should be because I now have information as the person who is being asked to do it. Now, I'm not going to do that in the other room, right? But when I talk to the party who's saying, well, you tell me what you think a fair buyout number is going to be, I'm going to, based upon the information, a fair buyout is nothing, right? If you tell me a fair buyout would be 0, but if you want me to come up with a buyout number, it's going to have a substantial discount rate on it. So, and some people don't, the thought of having to write a check and pull out a checkbook and write a check every month for the next 15 years, they would die a little every month. They'd rather just pay something up front and they don't care if they get remarried, they don't care if whatever they're going to do. And it is what it is. I'm more of a fan of reducing the amount and saying parties can cohabit, right? I will allow my spouse, my former spouse, or my future former spouse to be able to cohabit, and because of that, I'm not going to pay the full freight of alimony. I'm going to pay 75 cents on a dollar.
I've done quite a few of those, particularly when, when the circumstances, I see that cohabitation will potentially be an issue in the future. And I explain to people because a lot of us as matrimonial practitioners who do litigation, we've dealt with cohabitation applications. We know that it's an uncertain landscape. We know the hurdles that you face in order to be able to litigate those issues and the uncertainty as to the result. So I usually like to build in that part of our effort in mediation, at least when I do mediation, is I like to build in as much settlement and avoidance of future litigation as possible. So if we can come up with a resolution, such as what Jeffrey was describing, of let's do some sort of an alimony structure that anticipates that there will be an allowance of cohabitation, that there will not be a cohabitation application. You could save the clients can save themselves $50,000 going forward in litigating the issue of cohabitation, which sometimes resonates with people and they see the value in it. And while they don't always love it, again, it comes to the point of you don't have to love it, but can you live with it?
Right. And with creativity, right? We know a court can't order a buyout.
Well, cannot.
I've done buy downs, right? Where you buy out half of, you pay
I
half
have.
the amount because there is some risk, but so you get a discount on half of it, pay half of it out of some asset, and then leave the other piece of it that it's there, and there's less exposure on it or something, or then whatever. There are lots of hybrids of these things. There's no one cookie cutter answer that this is the right thing to do. And there's no one concept. These concepts can be blended. I have a question though, Candice. Oftentimes I know I'll bring in an accountant, to assist me to co-mediate, to get information, to figure out, to do some tracing, or to do a business valuation, or to do a cash flow analysis. Um, where does the privilege extend with them?
I think I think they are included in the non-party participant in a mediation session. If you look at the definitions, everyone at the beginning of the statute, I think they fall under the non-party participant. To the extent that they are participating in the mediation in an effort to facilitate resolution, I think their work product falls under that category. And I have often used accountants or leaned on accountants, whether it's to do valuations of businesses, whether or not it's to do even tax calculations, um, and help prepare budgets. I think it's incredibly useful because I don't certainly have that knowledge. I don't pretend to have that knowledge. And I think for a lot of people, it's very helpful. Particularly if they don't have attorneys that are representing them and they're not in the litigation space already, where maybe they've already engaged forensic accountants. It's helpful for them to have a financial person who can come in and help provide that much needed information. And even if they are in a litigation space, sometimes they haven't taken that extra step of getting an accountant involved. And when I point out to them, look, we really should get an accountant involved, and here, let me pull in somebody so they don't get into the battle of, well, whose accountant is it? I think it's helpful, and I think that they fall under that same umbrella.
Yeah, but then if you pull that scenario that you just gave, you pulled in someone, the case is in litigation, you pulled in an accountant to act as a joint to mediate. Now the mediation falls apart and they're going to trial. Can the parties now elect to use that accountant as a joint accountant for the litigation purpose?
I don't think that there would be anything to preclude them from hiring that person as a joint forensic accountant for the litigation purpose, but I think then they would have to do their own work outside of the mediation space.
Correct. Then I'll be honest, when I onboard an accountant, I didn't always do it. I've started doing it probably in the last 2 years. I have an onboard meeting, right? Like I'll schedule a 10-minute Zoom. Let me introduce the accountant. Let's talk about the scope of the work that we're asking them to do. And one of the questions I started asking in that meeting is, if this mediation falls apart, are we agreeing that we'll utilize this accountant as a joint expert? Because they could build that into the retainer agreement or their
Absolutely.
to provide services. They can build in that if it falls apart, they're only going to provide schedules which are inadmissible, and their agreement will say that. But that if it falls apart, that the parties can utilize them if they elect to as a joint, and they will have to do a full-blown analysis and report. That they can't rely just on their the schedules that were prepared otherwise for mediation. I know you can be creative in mediation. That's why people use it. Accountants don't have to prepare a report that's going to cost your client 50, 60, $70,000 to prepare. You can have them prepare schedules and for maybe $5,000 show up at the mediation and co-mediate with you and get the case done. I mean, that's what 99 times out of 100 is happening, right? So few cases end up in litigation ultimately. I think there is great value in involving someone who has a skill that I don't possess. Like we said, knowing what you know, knowing what you don't know. It's not just about diversity and inclusion. It's about areas that we don't. I'm not an accountant. I'm not an actuary. I'm not any of those things. We get pensions evaluated because we are not qualified to value them. I don't know how to value a business. I don't know there's no rule of thumb on business valuation. Businesses are unique. Accountants don't have that knowledge. So if you have the ability to bring in that accountant, I think it's important to, but I think it's also important to talk about the scope of the work and to talk about what happens if that mediation falls apart. Um, can a mediator subsequently represent one of the parties in a divorce proceeding in a subsequent real estate closing?
For me, it's always a hard no. Once I serve as a mediator and I'm a neutral, I would never represent. I've had clients, again, private couples who come and say, well, can you file the complaint for us? And I will always say no. If my name is on the top of a pleading, it's representation. I don't represent either of you. I know some mediators out there that will do it. I will not. I would not represent a mediation client after the mediation is over in any capacity, even if it had nothing to do with the substance of our mediation. And the same is true with, I routinely get asked in mediation, oh, can you be our parent coordinator after the mediation is over? The answer is always hard no. I mean, right now, obviously, our rules prohibit it, and the guidelines came out on parenting coordination prohibited, but even before then, it was always absolutely not. I cannot. I don't cross rules ever.
Yeah, I mean that I always think there's enough work to go around. You referring that case to someone else, that party becomes a referral source to you for mediation or for something else in the long run too. So why do that? Send it out to someone else to do, let them do it, let them handle it, and then you've built a good relationship with someone who becomes a referral source for you. And there's always goodwill in it. You may be losing that case, but I think you're gaining more on the back end of it than you would be otherwise. I think sometimes there's that, desire to try to keep the work, but I agree with you. I'd rather give it away. Can a mediator participate in a mediation when one of the party's children attends the same school as the mediator's children and the children are friends?
I think yes. Look, I've had we sometimes live in small communities, and I have had oftentimes people come and want to use me as a mediator because that I am known in the community, or I am known at my child's school, or what have you. And as long as both sides know it and there's a disclosure, and I don't feel like the relationship is such that it's compromised, I don't have a problem with it.
Yeah, I think to me it depends on how close my relationship is with those parents.
Correct.
If they have my cell phone number, the answer is probably a hard no. If they don't, then I'll probably okay with it, right? Like, because I think that becomes a problem is that then parties start crossing boundaries. I think you can do it. Again, it depends on the level of the relationship. If it's your child's best friend and you have created a relationship with one of those child, with the mother versus the father, I mean, I think you're not dealing with you're dealing with a conflict of interest I have a better relationship with the actual party, not just the children. And that,
Right.
so I think it is a little bit different. What about can a mediator participate in a divorce mediation with their relatives? If you have a relative.
I would not. I imagine there are some people that do. I don't know that there's any blanket prohibition, but I know for my own, just again, it comes back to that self-awareness. There are too many complexities with that sort of an arrangement that I would steer them to somebody else. I would steer them to you, Jeffrey.
I wouldn't touch it with a 10-foot pole.
Yeah.
And I'll be honest, I do the same thing even with like people at the gym, right? Like I know a lot of my friends from the gym who I see daily. Candice does remediation. And Alex ends up being their parent coordinator. But in any event, like because I just don't want every morning for one of those parties to be like, and what about this? And what about that? Like that's the last thing that you want to have that type of a situation created where the boundary and the line is going to be drawn and crossed, or where the other party who they may know you, but you might know one of the parties better, perceives what you're doing as something that might be otherwise inappropriate, or that you're biased towards one party. You never want to show a bias, and that there's potential to show bias in that instance. So I would avoid it. I think we have a question, Candice, do we?
I don't see one in the chat.
Yeah, and I think it's when a party's counsel joins a mediator's firm and the mediator withdraws, can counsel continue to represent the party in the same manner?
I'm just maybe I lost it. So
Okay, I'm mediating before I was here at Cohn Lifland, and one of my law partners, I joined the firm, I withdraw as mediator. Can that attorney continue to represent the client?
um I think that's okay,
I mean, my firm
potentially.
says no. My firm doesn't permit it. We
Oh,
say
your firm doesn't permit it.
yeah. If
Okay.
I was a mediator in the case and the case comes back to for post judgment here with them, they refer it out because I know the other party and I know I got potentially obtained information that
Do you think that there is a way to either
there
waive
is
the other side or to
ethically it
keep
can be
you
done.
walled off?
Ethically, it can be done.
Yeah.
There is a way to do it. There's a procedure and a mechanism in which you can do it. But it's just we don't. I'll be honest, we don't do it. It's something that can be done, but we don't do it. Um, can a mediator participate in a mediation when one of the attorneys is a social friend of the mediator?
Um, I
You're friends with the attorney. Can you
Yeah,
mediate?
I don't, again, these are like, I don't think that there is a prohibition against it. Would I feel comfortable doing it? Probably not. Certainly if it was on the line of how good of a friend is it, I would certainly want to talk to both attorneys about it. and just get it out there. I think a lot of it is just sort of disclosure, and seeing how everyone feels because the other attorney may not feel comfortable with it. And, a lot of times, and I think about our colleagues, a lot of our colleagues, you become friendly with. And I can say there are colleagues that I have that I know much better than other colleagues. And they come to me for mediation and I'm very friendly with one and I just meeting the other for the first time. I don't think that it prohibits me or I don't feel uncomfortable engaging in that mediation. But in those circumstances, I just treat every attorney the same. I don't, but I think it has, again, comes to knowing yourself and knowing whether or not the relationship is such that you feel like you would not be able to put a bias aside or that you would not be able to do it in a neutral fashion.
Yeah, I have forged, I'll be honest, I do it all the time. I have forged some very close friendships with attorneys over the years that I mediate for. I'm very upfront about it. I make sure the other attorney knows it. I bend over backwards not to show a bias. In fact, I'm probably harder on the person that I'm friends with. I'll probably give them a harder time than I would give the other side. Maybe that's my way of subconsciously. Evening the playing field, but it doesn't matter my relationship with an attorney, right? I mean, it's not about the relationship with an attorney. It's about being a neutral, and it doesn't matter what my opinions or thoughts are, or who I like and who I don't like. One of the questions I get asked a lot as a mediator is, if you don't like one of the parties, can you mediate for them? Now, a lot of mediators say, no, I can't. I can't. I say, assume I hate everyone because I.
Yeah, I was going to say I wouldn't have any mediations left. No.
Like, right, it's human nature. We're not gonna like everyone. Sometimes people do some really reprehensible things in cases, and you have to put that aside. You can't do if you can't separate what they did, and you can't, and if that bias is going to impact your ability to serve as a neutral, then yes, you have to withdraw. But if it's not, and you can continue to find that middle and work with those parties to help them find the middle that they want, because it's not my case, it's not my life. I mediate for people that I dislike all the time.
I
I
agree with you. Yeah,
mediate for
I do too.
attorneys that I'm good friends with all the time.
I
Um,
do too.
I disclose it. I disclose it. I'm very upfront about it. And I know Suzanne Reinschrift, for example, who I don't think is on this call, but like Suzanne and I were law clerks together. I've known Suzanne for 28 years. I've been to two of her weddings. We know each other very well, and she sends me cases, and I tell people, look, we were law clerks together. I've been to her, but I mediate her cases, and this is what it is, and the attorneys know about it, and they sometimes the attorney will want to talk to me in advance. If it's an attorney that I don't know, they might want to have a conversation with me. Fine, let's have a conversation. They want, what's my philosophy? How do I approach mediations? The nice thing about it, at this point, most attorneys who practice family law in the northern part of the state know who I am. And most of them are okay with it. Like, oh, I know Jeff too. So, maybe you're better friends with them than I am, but like everyone, I'm friendly with most of our colleagues. I was the chair of the family section for the whole state bar last year. I know family lawyers from all over the state. I've lectured with them, become friends with them, and friendly with them, and it does certainly, if it inhibited my ability to mediate, I wouldn't have a mediation practice.
Yeah, I
Ken,
agree.
I see you on screen. Is there
Thank you,
something you
Karen.
need to share with us?
Yes, I have a program code for everyone. Program code is EDF30. EDF30. And I'll also put that code in the chat.
EDF30.
Yes.
Karen, I
Thank
think
you,
you got to
everyone.
lift it higher.
Gotta lift
Oh,
it higher. There you go.
sorry, guys.
EDF30. Okay, excellent.
Thank you.
Okay, let's see. Okay, here's another one. Can a mediator continue to mediate when a mediator feels one of the parties is unreasonable?
Again, if I couldn't, I would not have any more mediations because there's always one party who I view to be more unreasonable, and I always find it a challenge to figure out how to reach that person and how to talk that person's language and how to get in, how to reach where they are, because there's always somebody who's unreasonable, otherwise they wouldn't be here.
Right. Can a mediator mediate dispute concerning religious upbringing of children when the mediator has very strong religious views?
I think that goes back to know yourself. Like if I felt that my personal life or my personal viewpoints would interfere with my ability to look at something neutral in a neutral fashion, then I would probably bow out. But I've never had that circumstance happen. I don't think it precludes us.
No, I mean, I know it's not, well, like, I think a lot of people use a religious exemption to avoid vaccinations, but
Sure.
I certainly have mediated many in a vaccination dispute, oftentimes with some level of success. It's just I am pro-vaccination, and I'll disclose that to them. But then I listen to them. There was a case the other day where the party was vehemently anti-vax. And I am very pro-vaccination. I mean, I don't think anyone who knows me knows that. But it was the fact he said to me at the end of it, he says, I really felt listened to in a way that no one else has ever before in this case. And he had like had three attorneys before. He was now self-represented. He felt like his prior attorneys hadn't listened to him. There had been two judges. It was post-judgment, so there had been two judges involved in the case. He felt like the judges had never listened to him, and he felt really listened to. And I think we ended up allowing certain vaccinations, but not others. So ones that had been more thoroughly vetted, ones that had more information on them. And like, but the fact that I took the time to go through the different vaccinations and the different studies on things and really, and look at it from that manner. Again, I built this level of credibility with a person who I flat out disagree with. Let me be honest. I flat out disagree with. And my views are very, very strongly contrary to their views. And I successfully mediated the case with the compromise that everyone could live with. So yeah, I think you again know yourself. Um, in those cases, I feel like when I know something like that is more prevalent, it's when it creeps up on you that it's dangerous, right? Like when you don't realize that you're having this effect. When I know flat out my views are contrary to this person's, I think I could take that in and really like hunker down on that and be very, very mindful of that, not to let my views on that topic seep in to how I'm dealing with the case. It's when you're not aware of it that it's dangerous when you're not aware of something.
I
I'm
agree.
very aware of the vaccination issue in this case and his opinions on vaccination versus mine. So I was able to navigate that. It's when something creeps up on you and you're not aware of it and it comes out halfway through the mediation and something like that. Usually I can separate it, but it's sometimes your gut reaction when you don't know what's coming. I have no poker face. I feel like everyone knows exactly what I'm thinking at all times. So sometimes, I'll be caught with my jaw on the floor in the middle of a mediation, and that's where I get worried and concerned about myself. So sometimes I'll be like, I need to take 2 minutes. It's okay to take 2 minutes as a mediator and take a breath and come back to it. If it's going to keep the mediation going and get you there, then I think it's a positive thing. With that, I think we're near the end now. Unless anyone has any questions, I'll ask Candice for any final thoughts that she might have.
Um, I Hold on, I'm just sorry. There was Karen had put the thing in the chat. I thought there was a question. I think ultimately our biggest takeaway here is we all are here because we believe in the process, whether we are mediators ourselves or whether we use mediators as part of our practice to help our clients get to the end of the road. We all believe in this process. And the better we can serve our clients, whether as mediation clients or litigation clients in mediation, the best way we can meet and service our clients is to be sort of sensitive to not only the cultural competency and awareness issues, but also remembering sort of where our lines are, where our ethical lines are in terms of engaging in this practice. To me, it always comes back to trust your own inner barometer. We talked about self-awareness a million times today because I always go by my gauge of if it doesn't feel right, it probably isn't right. Whether it's in dealing with a case where I'm just not familiar enough with the landscape, the cultural landscape, or the specific needs of this family, or whether it's an ethical issue. If it doesn't feel right, then I'm generally not going to do it. But I think that is always a good way of sort of gauging what we do in our practice because our ultimate goal is to help people. And if we're going to help people, then we have to be mindful of who they are and what they come to the table with, because it isn't about us, it's really about them. It's their case, it's their life, and my objective is to help them get through.
Yeah, I think it's follow your gut is my biggest takeaway. Follow your gut. If it doesn't feel right, you probably shouldn't be doing it. If you feel like you have a bias that you're not able to work around, don't do it. If you feel that you don't have enough information to tackle an issue, don't do it. If you if it feels wrong to you, it's probably wrong, or or a bias that you have is probably otherwise creeping in. And I think the other one would be don't necessarily feel afraid to take risks within the confines of ethics, right? Take risks as long as it's not going beyond what ethics provide. Be willing to roll your sleeves up and get involved to try to find something creative for the parties in a creative manner. Um, the vaccination issue. I mean, like a lot of people, like they just can't be mediated. You can't mediate. People have such strong views, you can't mediate. I've successfully mediated about 5 vaccination cases. Where party, they're not easy. They're not easy, and they didn't happen just because one party all of a sudden decided, yes, I'm okay with no vaccinations, or yes, I'm completely okay with vaccinations. Those are things that people, have very, very strong views on. But, finding if there is a middle ground to be found, explore finding what might be a middle ground. Is it setting an age will allow the vaccination to be given at a certain age? I don't know. Play different cards, play different things. Don't be afraid to throw things out to see what might work, because what's the harm? You might find the settlement, right? And they'll avoid trial. That's the worst thing that could happen. Is that you'll succeed. Or if it doesn't, the trial process is there. So as long as you're not crossing the lines of ethics, or I think you're okay. I think it's that's what makes a good mediator a good mediator. Take risk, the ability to take risks within the confines of what ethics allow. With that, we're at 1:40, Karen. Did we hit the time mark?
You did good. Thank you. On behalf of the Passaic County Bar Association, thank you, Jeff and Candice, for this very informative seminar. And we wish everyone Happy New Year.
Happy, healthy.
Happy New
Happy,
Year, everyone.
healthy to everyone.
We'll see everyone in 2026.
Thank you. Thank you again, Jeff and Candice. Thank you.
Thank you, everybody.
Have a good New Year, everyone.
Bye-bye.
Bye.